Good morning. Thanks for joining us. I hope you're all keeping safe and well. So this is the second in the series of our virtual rural business briefings programme. Our first session was in September, where we had a focus on agri-tourism. The programme's aimed at forward-thinking owners and managers of estates, farms and businesses in the rural community, with presentations on the pressing issues and the latest updates to keep you informed. Future topics will include alternative land uses, agribusinesses and succession and multi-generational farming, and you'll receive further details and invites for these sessions shortly. For today's session, we're focusing on land ownership. So for the agenda today, we're delighted to be joined by Sarah-Jane Laing, Chief Executive of Scottish Land and Estates. She'll be sharing her insight and views on land ownership challenges and opportunities. Kate McLeish will be covering the legal aspects, process and latest guidance concerning community right to buy. Claire Dunlop will be providing a talk on residential leasing and an update. And then Scott Logan will be sharing some top tips in dealing with telecoms operators. We'll then be joined in the Q&A session by Fiona Scott, who has expertise on residential leasing also. So many, of course, of you will know Sarah-Jane, but we thought we'd just provide a little bit of background to introduce her session. Sarah-Jane was appointed as Chief Executive of SLE in December 2019, the first woman to hold this role in the organisation's 110-year history. Leading a team of 25 SLE colleagues based across Scotland, Sarah-Jane's role includes influencing the UK government on a wide range of issues that will impact rural Scotland. At Holyrood, her focus is on addressing climate change, increasing the supply of quality, affordable rural homes, and developing a post-Brexit land use policy which delivers resilient businesses and thriving rural communities, as well as increased environmental resilience and wider societal benefits. She's also responsible for encouraging Scotland's landowners, whether they're communities, private individuals or charities, to be open, inclusive, enabling and responsible through SLE's Landowners Commitment. I'll now hand over to Sarah-Jane.
Thanks very much, Karen. And it's actually quite nice to get a reminder that my role involves something other than dealing with COVID and providing support and advice to members and trying to get our heads around the implications of each daily change in the guidance to landowners and rural-based businesses. Karen asked me to speak to you about ownership, and as usual, I've kind of gone slightly off topic because for us, it's very hard to separate land ownership and land management. In fact, that's one of the points that we often made to the Land Reform Review Group and we continue to make to politicians. If I can start with kind of the macro level for landowners and land managers, and I'll level with you, the biggest challenge we have in 2020 and ahead of the May 2021 elections is a political one. The false impression that half of Scotland is owned by only 432 people has led a couple of the parties, Labour, the Greens and some of the SNP, to believe there's little votes to be lost in bashing the rural landowners. So what we're likely to see in some of the manifestos from Scotland's parties ahead of next May will make uncomfortable reading for Scottish landowners. We are likely to see ambitions to further land reform. Some of these will be based on evidence, some of them will be based on long-held ideology. And many of the commitments in those manifestos will be based on the work of the Scottish Land Commission. Now, some of the work the Scottish Land Commission has done has been very positive. It's helped to shine a light on the realities of relationship between tenants and landlords. It's also highlighted the real difficulties in terms of community ownership. But the recently published SLC strategic plan also makes some worrying reading about some directions of travel in relation to the pattern of land ownership in Scotland and the ambitions of the Scottish Government, the SLC and others to address the concerns that they have about the continued concentration, not just of land ownership, but of the power that they feel goes along with that. So things like a public interest test for large, significant transfers of land aren't yet off the table. They're still being suggested and explored for post-2021 consideration. As are other intervention measures in relation to derelict and vacant land, this isn't just about rural land holdings anymore. It's about significant land holdings in our urban areas. The SLC is also looking at how it can use taxation and other fiscal levers to address land ownership, especially the concentrated pattern of land ownership. And a number of the Scottish Land Commissioners have major concerns about the increased land ownership by the rewilders, which is I have to say, a kind of catch-all term for lots and lots of environmental NGOs, but also private landowners who are increasing their land holdings to deliver government targets on climate change and tree planting. So it does seem ironic that one of the parts of government are encouraging these landowners, the land use, but they have an underlying problem with the ownership aspect of some of these holdings. And the other part of the work that the SLC will continue to do is in relation to protocols and landowners' responsibilities. We were a bit disappointed that land rights and responsibilities seems to focus very much on the landowners' responsibilities and land users' rights. And I think during COVID, we saw that balance tip even further. The unacceptable behaviour that we saw from many visitors to rural Scotland, I think actually has been a good thing in terms of changing political viewpoints on the Outdoor Access Code, but also on the underlying land rights and responsibilities statement and the protocols which flow from that. So we're starting to see some political support for our calls to focus not just on the landowners' responsibilities, but also the landowners' rights and the responsibilities of those who take access and use our land. I can't mention land ownership and the SLC without touching on ag holdings, and I do want to thank Kate McLeish from Roadies for all the support that she's provided to the Scottish Land and Estates over the last few years. The Land Reform Act of 2016 feels like a lifetime ago, I have to say, at the moment, but we still haven't seen many of the provisions on agricultural holdings implemented, largely because, as Kate and I told the Scottish Government at the time, most of the provisions in the Act were unworkable technically. And sometimes it's very hard not to say "I told you so" to the civil servants and politicians. We're not going to see a change in the rent review methodology. We are still waiting for measures on relinquishment and assignation to even get to draft regulation stage. But what we are seeing is actually a positive move. It's a call from the Tenant Farming Commissioner, Bob McIntosh, to focus on new relationships, new ways of jointly working together through joint ventures, and really making sure that both the landowner and his partner, formerly the tenant, both have some skin in the game, and trying to make sure that it's a much more equal partnership going forward. And I think that's been a very positive move. It's certainly something that we didn't see from the previous tenant farming lead, Andrew Thinn, but Bob McIntosh really has changed the climate and discussions around that. I can't talk about ownership without talking about ownership of a particular asset in Scotland, and that's moorland, particularly those who own grouse moors. You'll be aware of the Werity review into grouse moor management, which touched not only on how those moors were managed, but the behaviour and responsibilities of those who work on that land and those who own the land. One of the early calls was for visibility of owners, linked very much to the vicarious liability provisions which came in through the Animal Welfare Act, the Wildlife and Natural Environment Act, and then strengthened during the land reform debate. I'm delighted to say that owners largely responded to that. We see much more visibility, much more transparency, and have definitely seen a willingness to showcase the fantastic work that goes on in Scotland's moorland. And that was reflected in the Werity Review. It often gets lost that many of the recommendations there were about just tightening up and improving some of the practice in relation to muirburn, medicated grit and the culling of mountain hares. Because what's often talked about is the licensing of an estate, the licensing of Grousemoor estates linked to populations of 3 raptors in Scotland. The Scottish Government, although it's had the Werity Review since last December, is still working on its response. That is due out this month. We've had the heads up that the Scottish Government plans to respond to that this month. It might be delayed now because of the latest COVID developments, but it's certainly something that we are aware is getting full cabinet consideration. And I do think that's worth pointing out. It's back to my first point. Land ownership remains a political football in Scotland, and anything linked to large-scale land ownership and the perceived elitism of land use and ownership in Scotland is something that's discussed on a regular basis at full cabinet level. It's something the First Minister pays a particular interest in, and she's not averse to making some fairly strong statements in the chamber. On the positive side of things, because there's always a positive, there are lots and lots of opportunities coming up for Scotland's landowners, primarily in the realm of natural capital and how we address climate change, because underlying this is carbon storage. So whether that's sequestration in our peatlands or increasing our woodland coverage in Scotland, landowners have a real place to play. And I think that's where you start to see a shift in that. Sadly, though, that's often coupled with concerns about deer management, grouse, as I've touched on, and other underlying concerns about subsidy, especially subsidy going to larger landowners. On subsidy, we still have no long-term vision for Scotland's post-CAP world. We're not sure of anything really beyond 2024. However, I do think that climate change will be the driver. I think we will see a move away from producer or production-based subsidies. That won't happen though in the next parliamentary period. That will be beyond 2025. So lots there for landowners to be concerned about, but even more, I think, for landowners to be optimistic about. How Scotland's land is used, the strong relationship between Scotland's people and its land, I think, provide far more opportunities than threats for Scotland's landowners and all of us who advise them. Karen, I know we're taking questions at the end, and I'm happy to take questions on anything that I can be helpful on, and not just the topics I've covered today, but back to you, Karen. Thank you.
Thank you, Sarah-Jane. And you said at the start just how busy you are with the COVID advice you're giving, and just with the 5 minutes with you at the start before the seminar, it's apparent how busy you are with that and the amount of advice that is required for rural businesses and your members throughout this period. So thank you for that. So our next speaker is Kate McLeish, who's a partner in our rural team and an accredited specialist in agricultural law. Kate acts for landed estates, farmers and agribusinesses across Scotland, and she deals with the full gamut of property-related matters. Today, Kate is turning her attention to community right to buy, and she's going to speak to us about processes and latest guidance on that topic. Thank you, Kate.
Thank you for the introduction, Karen. So this morning I'm going to summarise the community rights to buy which apply in Scotland, and also give you flavours of the protocols and guidance which are relevant to the wider discussions about community ownership and engagement. So the first community right to buy was introduced in Scotland by the Land Reform Scotland Act 2003, Since then, it has been tweaked and added to, but we still do have the right, which was first introduced in 2003, and that is the preemptive right to buy. So the key part of the preemptive right to buy is that it requires a willing seller. So a community can create a community body in terms of the legislation and register an interest. In order to be able to register an interest in land, the community has to meet a number of criteria, and these include that the acquisition of the land is compatible with furthering the achievement of sustainable development, that it is in the public interest, and that there is community support for registration. If an interest has been registered and the landowner decides to sell the land and serves the relevant notice on the community body, the right to buy will be triggered. And there's a separate process for the activation and exercise of the right to buy in terms of the legislation. The only exception to that, which slightly murkies the waters, is what is known as a late application. And that's the kind of application which is registered after a landowner has already advertised land on the open market. More rigorous tests apply in those cases, and the policy behind that is that the community right to buy is intended to be a proactive process to encourage community bodies to look at the land assets around them rather than react to land being put on the market. There will always be further tests which have to be met before a community body is able to exercise that right where a landowner is prepared to sell land. And the Scottish ministers have of course to consent to the exercise of the right to buy, and the legislation sets out when and when they cannot consent. So they can only consent if the land purchase is in the public interest and the community has improved it. And that means that there needs to be some kind of ballot and the majority of the community need to have voted in favour of the exercise of the right to buy. Perhaps the most important aspect of the process, and certainly from a landowner's perspective, is that the legislation provides a methodology for the price that has to be paid for the land. So the legislation provides that the community body has to pay market value of the land at the time that the landowner gave notice of his intention to sell. The legislation also sets out that market value will be the aggregate of the value that the land would have made on the open market between a willing buyer and a willing seller, but also takes account where only part of the land is being purchased by the community. So it will include any reduction in value for other land which the community is not buying. So that is the preemptive right to buy. And because of that kind of two-stage process, it can be a little bit of a waiting game from a community body's point of view. They have to register an interest, they have to wait for the landowner to serve notice to transfer the land. And then, of course, that activates the right to buy and they can seek to exercise it. The next right to buy, which we have, was introduced in 2015, and it is very different from the preemptive right to buy because it is a compulsory right. It does not require a willing seller. So land which is eligible for this right to buy for neglected and abandoned and detrimental land. So land will only be eligible if it is wholly or mainly abandoned or neglected, or the use or management of the land is such that it results in harm to the community. There are some kinds of lands which are excluded from that definition, and importantly, one of those exclusions is that people's homes cannot be purchased unless they are tenanted. So an owner-occupier cannot have their home compulsorily acquired. It's actually a much more straightforward process when you're dealing with the right to buy for the abandoned and neglected land, and that's because it's not preemptive. So instead, we just have an application for consent to the Scottish ministers, and the Scottish ministers have, of course, to consider the list of criteria for consent, including again that it must be in the public interest for the right to buy to be exercised, it must further sustainable development, and importantly, that the community has tried and failed to buy the land by other means. So again, this means that the community cannot jump to exercising a statutory right to buy. They should have tried to negotiate with the landowner, and those negotiations must have fallen down. And again, the legislation provides for a valuation methodology to ensure that the landowner is getting a fair price, and that is the market value. In this case, market value also includes disturbance to the seller, and that of course reflects the fact that this is a compulsory purchase and therefore envisages that the seller might have been disturbed in some way. Finally, we have the right to buy land for sustainable development, and this is relatively new. It was introduced by Land Reform Act Land Reform Scotland Act 2016, and it only came into force in April 2020. The right to buy land for sustainable development doesn't focus so much on the condition of the land, which is what neglected and abandoned rights to buy look at. Instead, the right to buy for sustainable development focuses on what use the land can be put to by the community body, and also potentially looks at the use which is being put to just now by the existing landowner. So again, certain conditions have to be met. And as you would expect, perhaps these are even more rigorous. The test applies that it must further the achievement of sustainable development for the community body to exercise the right to buy, that it will result in harm to the community if consent is not granted, and that granted consent will give significant benefit to the community, and that this is the only way to achieve that benefit. So as you can see, there are quite a number of tests which apply there. Unfortunately, the legislation is lacking in detail in a lot of exactly what those tests mean. For example, sustainable development, which is something which is referred to throughout the community right to buy legislation, is not actually defined. Likewise, what constitutes harm, what constitutes a significant benefit. However, it's clear that the legislation is trying to ensure that there are rigorous tests in place for the sustainable development right to buy, given the potential impact on a landowner's rights. And a key aspect as well of the provision which differentiates the sustainable development right to buy from the other rights is that it is possible for a community body to nominate a third party purchaser to take title. And therefore it's possible to envisage that there could be room for some kind of joint venture arrangement, which would no doubt assist with funding of any purchase. So those are the different rights to buy. I should say I've simplified the process hugely. The legislation sets out in huge amount of detail about what must be included in any kind of application by a community, what the basis of consent must be by the Scottish ministers, what rights a landowner has in terms of what timeframes he can expect to be complied with, what appeals he might be able to make if he is concerned about the direction of travel. For example, about the valuation, it's the process for valuation, which must be carried out by an independent assessor. All of this is set out in the legislation. Now, as you can imagine, given the detail which is in the legislation, it can be quite dense. But the good thing is that there are various guidance documents which set out in detail both what a community body should do and what a landowner should do and can expect the other party to do when going down this process. So the Scottish ministers have, of course, prepared guidance. But in addition, Community Land Scotland has also prepared a substantial amount of guidance on the statutory process. And they've also published joint guidance with Scottish Land and Estates about how to conduct a negotiated sale. And that highlights that although community bodies do have these statutory rights to buy, it is of course open to them to negotiate with a landowner. And what that joint guidance is trying to do is to set out how that kind of negotiation should be conducted. The Scottish Land Commission has also published various surveys and reports about community ownership and some of the challenges which it might face. So in summary, for anyone who is looking at ownership of land by communities, whether it is a landowner who is concerned about the risk of a community body seeking to exercise a right to buy, or whether it's a community body who would like to exercise a right to buy, there's a substantial amount of guidance and information which is available. However, the statutory community rights to buy are only part of the story, and that's because there's a much wider discussion ongoing about how communities are involved in decisions relating to land. So not just about how they take ownership, also about wider discussions relating to land and how they might be involved in them. So the Land Reform Scotland Act 2016 obliged the Scottish Government to prepare guidance on engaging communities in decisions relating to land. And that's pretty much all it said, leaving it up to the Scottish ministers to produce the guidance. The guidance has been produced and it makes clear that it applies to anyone who has control over land, whether that is an owner or a tenant, and that might be a public authority or a private owner as well. And the intention is to try and ensure that people are involved in decisions relating to land which affect them. The guidance advises that community engagement is particularly important for situations where a decision about land is likely to have a significant impact on the community. And it also states that the type of engagement should be proportionate to the impact of the decision to be made. The guidance sets out a few kind of guiding principles that refers to it. Engagement must be proportionate, as I've just said. It must be genuinely collaborative, and any kind of communications must be ongoing. So the expectation is that the community would be updated, and certainly after a decision has been made, they would be given feedback. I would say that the guidance itself is very clearly set out. It is trying to manage expectations about when communities can expect to be engaged with, and also what that engagement might look like. If it's more decisions about day-to-day management, it makes it clear that the kind of engagement is going to be radically different from longer term decisions which will have an impact. And finally, we have a Scottish Land Commission protocols. So as Sarah-Jane has already alluded to, the Scottish Land Commission have quite a wide remit when it comes to land in Scotland. And as part of their various work streams, they have launched what's described as a good practice series. And as part of that good practice series, so far they have launched 2 protocols. The first relates to land tenure, but the second relates to communities. And they seek to set out specific expectations which communities can have. And these include that landowners should consider proactive requests for land transfers and try and be open and transparent about any decisions that they might make. It also sets out that when a landowner is selling land off market, they should make the local community aware. So the Scottish Land Commission is essentially trying to encourage landowners to consider the implications of their decisions and speak to communities at an early stage. And again, what the protocols are trying to do is set out with their specific expectations what actually is reasonable to expect. So that is a very brief summary of the considerations which might apply if you are a community body looking to buy land, or alternatively, if you are a landowner who is either potentially considering a land transfer or is simply making a decision which will be affecting a local community. And if anyone has any questions, I'm happy to take them at the end. But in the meantime, thank you very much for your time. And back to you, Karen.
Thanks very much for that, Kate. Our next speaker today is Claire Dunlop. She's a senior associate in our rural team, and she advises both the rural and urban sector property owners in respect of all matters relating to private rented sector, including advice on leases, applicable housing law, and rights of termination. And that's in addition to her normal day job, where she specialises in complex purchases and sales of estates and forestry. So thank you, Claire, over to you.
Thank you, Karen, and good morning, everyone. Next slide, please. So this morning, I'm going to cover the impact of COVID on ending a tenancy and have a quick look and remind ourselves about the energy efficiency and changes to the repairing standard. And then I'd like to bring to your attention the consultation on the regulation of short-term lets. Next slide. So the impact of COVID-19 on ending a tenancy, I've put a few on here. The first, this one and the next one relate to private residential tenancies. And what I've done is to set out the grounds on which you can obtain possession of a house let on a private residential tenancy, and set out whether that ground is usually mandatory or discretionary, and the usual notice periods. And then in the last 2 columns, this reflects that all grounds for possession of a private residential tenancy are currently discretionary, and that notice periods have been extended. So the last column there is the current notice period for ending a tenancy. And on the next slide, I just want to highlight 2 of the grounds of possession, which is relevant criminal conviction or criminal behaviour and antisocial behaviour, because the notice periods were changed for any notice given on or after the 3rd of October. The notice period has been reduced back to 28 days there. And on the next slide, I've got the same table essentially, but this relates to short assured and assured tenancies. And again, it just sets out the same information, but relating to these types of tenancies. And again, on the next slide, there is a reduction in the notice period from 3 months to 28 days if you're ending a tenancy on the ground of antisocial behaviour. And that's only in respect of notices served on or after the 3rd of October. I'd also just like to highlight, when talking about short assured tenancies, that ending a tenancy at the end, so using the no fault ground, is also currently discretionary and also has an extended notice period. I haven't put in anything specific about protected or regulated tenancies, which are those granted before January 1989, but the grounds for ending those are also discretionary and notice periods have also been extended. So on next slide. So I want to move on now and remind ourselves about energy efficiency and repairing standard changes. And this slide reflects what was meant to happen. Regulations were meant to come into force on the 1st of April 2020, and the restrictions shown on the slide here were meant to come into effect from the 1st of October this year. So all these dates are now uncertain, but we do expect that the regulations will be brought forward at some point. So next slide. There will be exemptions. So in other words, there will be instances where you can let a house which doesn't meet the required energy efficiency level. And one of those exemptions relates to the cost of improvements. And the cost, and this is known as the cost cap exemption. So what was originally intended was that if the cost of making improvements would exceed £5,000 in the period from the 1st of April this year up to 31st of March 2022, or then after March, when you're trying to get to the next energy efficiency band, the work exceeded £10,000, again though, the period for work being carried out started on the 1st of April, then you could apply for an exemption. And as you'll see, these costs were cumulative. But we await hearing at the moment the date at which you'll be able to carry out works from, and whether that date of the 1st of April this year for carrying out qualifying works will be kept. The next slide, I'm not going to go through in detail, but it is just an example of how the cost cap might work. It does use the original dates, but it is quite a useful example for working through how it would work and what it means. Next slide. This just sets out that there are offences if you don't comply with the regulations or when they come into force, and the fines which relate to those offences. So on the next slide, we're looking at the repairing standards changes. I just want to highlight the holiday lets. It was clarified in March 2019 that holiday lets did not have to comply with the repairing standard, but I'll come back to this point later when we're talking about potential licensing for holiday lets. Fire and carbon monoxide detection, that will become part of the tolerable standard as well as the repairing standard from February next year. And so it's just worth noting that those requirements will apply to all residential properties and not just those in the private rented sector. The next main change to the repairing standard comes in March 2024, when to meet the standard, houses will have to have safe kitchens, fixed heating systems, safe common parts and secure doors, and circuit breakers. And also provisions regarding gas and electrical systems will also apply to other fuels. And also a reminder that come March 2027, all houses within agricultural tenancies will be brought into the repairing standard. So if I can now move on to the next slide, and I want to bring to your attention the current consultation on short-term lets. Now, I'm sure you're all aware that the Scottish Government intend to regulate short-term lets. And their approach is two-pronged. So next slide. the local authorities will be entitled to designate short-term let control areas within their districts, and all short-term lets within those areas will require planning permission. But running alongside that, they will be introducing a licensing scheme. And this consultation looks at the regulations required to bring all of this into effect. The target date for this starting is April 2021. So on the next slide, I wanted to highlight the one aspect of the consultation, and it proposes a definition of short-term lets. And the definition will be quite wide, because a short-term let will be a let where all of the following criteria are met, and that's all the criteria listed on the slide. The let will be made to one or more guests for them to reside at the accommodation. The accommodation can be all or part of a house or a flat or serviced apartment, but not on the premises of a hotel. And the accommodation must not be the guest's only or principal home. Now, there isn't any upper or lower limit proposed as to how long a guest has to stay, only that it's not their only or principal home. And the let must be for commercial consideration, but the consultation makes it quite clear that this is not only money, but it could be a benefit to the host, such as providing a service to them, or reciprocal use of another property. And the final criteria is that none of the guests should be members of the same immediate family as the host or the host's household. Now, the licensing scheme will be implemented at local authority level, and they can introduce schemes from the 1st of April 2021. But they will have to have schemes up and running by the 1st of April 2022. And this is all what is proposed in the consultation. Now, certain licence conditions will be mandatory and will apply throughout Scotland. But local authorities will also be able to add their own conditions to address local needs and concerns. So the next slide, I've put in here an annexation from the consultation, which sets out the proposed mandatory licence conditions. And I'd just like to highlight here that the one at the top is that houses meet the repairing standard. So while in 2019, it was clear that in terms of housing law, holiday lets were not caught by the repairing standard. In terms of the licensing regime, it is proposed that they are required to meet this standard. Now, the other thing to note here is that some of the conditions you'll be able to self-certify as the applicant, whereas others will require verification. So I don't have time today to go through the consultation in much detail, but it is a live consultation at the moment. And on the next slide, I've given you the link to it so that you can go and see the details for yourselves. And responses are to be in to the Scottish Government by the 16th of October if you want to respond. So thank you very much, and I'll hand you back to Karen now. Thank you.
Thanks, Claire. Thanks for that. Our next speaker today is Scott Logan. Scott's a managing associate in our rural team, and he specialises in compulsory purchase and utilities work with a particular interest in telecoms. He's regularly advising rural landowners and businesses in relation to telecoms masts, cabling and statutory powers under the Telecoms Code. Thank you, Scott.
Thank you, Karen. Can I have the next slide, please? I'm going to provide an update on telecoms and the operation of the new Electronic Communications Code, which came into effect at the end of 2017, and share some top tips in dealing with telecoms operators. The code provides a statutory framework for the installation and retention of telecoms apparatus on land, and gives designated operators powers to compulsorily acquire rights on land where agreement cannot be reached. The code was rewritten in 2017 with the intention of making it easier for network operators to deploy and maintain their infrastructure. Whilst the new code undoubtedly provides operators with enhanced statutory powers, it does not give them carte blanche, and an increasing number of recent court decisions have gone against them. We have had first-hand experience of operators and their agents acting in an overly aggressive manner, being very quick to threaten court proceedings unless the owner agrees to their terms. In many cases, their position is not as strong as it is made out to be, and any approach from an operator for a new site or a renewal should be considered very carefully. We'll come on to look at the operator's powers and the application of the code in the context of both an approach for a new site and an approach for a renewal on an existing site. However, I will just start by covering the termination of telecoms, leases and agreements. Next slide, please. In agreeing to the installation of telecoms apparatus, you should be aware that once it is installed, the statutory protections afforded by the code make it very difficult to recover possession of the land and have the apparatus removed at the contractual expiry date, or indeed at any point after that. Regardless of the contractual period coming to an end, code rights continue on a statutory footing until they're terminated in accordance with the code. The circumstances in which code agreements can be brought to an end are limited and are set out in the slides there. They can only be terminated at or after the expiry of the contractual term, and a minimum of 18 months notice must be given. Leases for mass sites will typically be granted for a term of at least 10 years. And if there's any development potential or aspiration within the initial contractual term, the lease should contain a break option allowing the owner to terminate on 18 months notice if the land is required back for development. We would also normally look to include a lift and shift provision, allowing the apparatus to be relocated at the operator's cost if it cannot be reasonably accommodated elsewhere. Next slide, please. So coming back to an approach on an entirely new site, what rights do operators have? The basic premise of the code is that operators require the agreement of the owner to install and operate their equipment on land, but with recourse to the Lands Tribunal to impose terms if agreement cannot be reached. The procedure for obtaining a court-imposed agreement requires that notice be given, setting out the code rights required and the proposed terms of the agreement. If the owner does not agree to confer the rights and the terms sought within 28 days, the operator can then apply to the court for imposed terms. The court may impose terms if it's satisfied that two access tests are met. Firstly, the prejudice caused to the owner must be capable of being adequately compensated by money. And secondly, the public benefit in having access to communications networks is likely to outweigh that prejudice. The access tests are likely to be met in most cases, but there will be some exceptions. There's also protection for owners intending to develop their land. The tribunal cannot impose rights if it is satisfied that the owner intends to develop and could not reasonably do so if an order were made. It will be for the owner to satisfy the court that there is a genuine and settled intention to redevelop and that the development cannot proceed if the order is made. Next slide, please. So what terms can the tribunal impose? If the access tests are met and there's no intention to develop, the tribunal can impose an agreement which gives effect to the rights sought by the operator, but with such modifications as the tribunal thinks appropriate. The agreement must also contain such other terms as the court thinks appropriate, including provision for the payment of a consideration. Again, next slide, please. The new code introduced a new basis of valuation, which was intended to reduce the rents being paid under telecoms agreements. Whilst the consideration or rent is to be based on a market value, this is subject to a number of assumptions, the key one being the no network assumption, which disregards the telecoms use. This has in turn led to a considerable reduction in rents for new sites. And the first Scottish case to determine consideration under the new code, Cornerstone against Fotheringham, set the rent at £1,500 for the first year when the imposition on the landlord will be greatest, and then £600 for the subsequent years following the initial installation. The tribunal recognised that the impacts of the agreement on the landlord should be taken into account when assessing consideration. If an owner is willing to proceed on a voluntary basis, there's often scope to secure better financial terms and include greater protections within the agreement through negotiation. Whilst operators are reluctant to increase the rent, it is common to agree an upfront payment for completing the lease quickly. As for the terms of the agreement, the standard form documents used by operators are heavily weighted in their favour and give the operators rights which go well beyond that contemplated in the code. It is therefore important to limit this where possible to reflect the corresponding provisions in the code. Next slide, please. For example, the new code gives operators powers to upgrade and share use of their apparatus with other code operators. However, this is a qualified right, and upgrading or sharing is only permitted where any changes resulting from the upgrading or sharing have no more than minimal adverse impact on its appearance, and the upgrading or sharing imposes no additional burden on the owner. The power to upgrade and share relates only to the apparatus covered by the agreement. Now, this is an important point. It does not confer a right to install entirely new additional apparatus. Therefore, the agreement should specify the apparatus that can be installed and limit what can be upgraded or shared. Next slide, please. Similarly, operators now have the power to assign agreements freely to other code operators. However, the code only deals with assignation between code operators, and therefore the lease should restrict assignation to non-code operators. The new freedom to assign is a significant concern to landowners, as the landowner will have no control over the identity of the tenant going forward. The code does, however, permit a condition requiring a guarantee agreement to be provided on assignation, and owners should always insist on a guarantee being provided on each assignation, and for that to happen, it must be agreed in the heads of terms and then reflected in the lease. Next slide, please. I've already touched upon a number of practical considerations when negotiating telecoms agreements, but we'll mention a couple of further points. Firstly, access. Operators are usually looking for 24/7 access with little advance notice and indeed no notice in the case of emergency. We normally look to include an agreed access protocol in the lease, covering notice periods and the information to be contained in the notice. For example, personnel or contractors attending, when and for how long, types of vehicles and machinery that will be used, the works to be undertaken, biosecurity measures, and so on. The protocol can also deal with access restrictions, for example, permitted hours for routine works and restrictions during sporting seasons or forestry operations. Whilst telecom sites are usually very small, the impact on the wider landholding must also be considered. For instance, mass site leases usually allow the operator to fell trees which interfere with line of sight. And so if this will have an impact on forestry, this should be identified at the outset and be reflected in the compensation package. And next slide, please. Moving on to look at the situation where an operator approaches you for a renewal of an existing agreement which is approaching or has passed its contractual expiry date. The new code provides a mechanism for court-imposed modifications and renewals. In this case, either party can apply for the modification, but only at or after the end of the contractual term. The procedure requires notice to be served on the other party, requiring agreement to the new terms, and a minimum of 6 months' notice must be given. If agreement is not reached within that 6-month period, either party can then apply to the tribunal for an order modifying the agreement. The tribunal may extend the term of the existing agreement, modify its terms, or substitute a new agreement in place of the old. As renewals are subject to the new code valuation principles, operators have been using this procedure to push rents down on existing sites. However, in a decision just handed down 2 weeks ago, EE and 3 against Duncan and others, the Lands Tribunal refused the operator's request to terminate existing agreements and replace them with new agreements at reduced rents, as the operators had failed to make out their case. The tribunal focused on there having to be needs which justified the replacement of the existing agreements and made it clear that convenience is not enough. The operator's desire to have the new code rights to assign, share and upgrade and to reduce the rents payable under existing leases did not satisfy the needs test. Whilst there is every likelihood that this decision will be appealed, at least for the time being, it represents something of a game changer If you're approached for a lease renewal or are already in discussions for a renewal, then you should consider your position very carefully before proceeding further, and certainly do not take it as a given that the operator will be able to reduce the rent or otherwise improve their terms. If the operator is willing to commit to the current rent for an extended term, then that may be an option worth considering. However, any new agreement will be subject to the enhanced new code rights, and this is also likely to be the case with any extension of an existing agreement. On balance, it may be best just to leave the lease to run on year to year at the current rent. If you are willing to negotiate an extension or renewal, then many of the considerations that I mentioned earlier will apply equally here. That brings me to an end of my section, and I will now hand back to Karen. Thank you.
Thanks, Scott. So we'll now move on to our Q&A session. Please do keep your questions coming using the Q&A box at the bottom of your screen, and include your name. And if we can't get to them this morning, then we will come back to you separately. As I mentioned at the start, for the Q&A, we're being joined by another of our colleagues, Fiona Scott, who is another member of our rural team, acting principally for landed estate owners, advising on the full spectrum of rural property matters. But she also has an expertise in the private residential sector, advising on leasing. So I'm going to ask questions as they appear, so apologies if I'm jumping around between the panel. But there is a question received for Sarah-Jane. Sarah-Jane's back. Sarah-Jane, I'm going to kick off with a question that's been received for you. What area of the Scottish Land Commission's work causes you the most concerns?
Probably the fiscal ones. The land value taxation, the land value capture stream. Some of the measures which have been talked about there, I do think would disproportionately affect rural landowners, and I do think that they're not fully thought through. So the Scottish Land Commission is kind of lacking in economic knowledge. So they're based more on, if I can kind of call it, social economics than proper sort of proper economics. So I do worry that it's something that the SNP and others will buy into. I'm not as concerned about the measures such as public interest and the other measures to address concentrated patterns of land ownership that are mentioned, and primarily that's because I don't think they're compliant with ECHR.
Thank you. And we do have, in your talk, you touched on carbon sequestration. And so there's a question that's come through about carbon sequestration and what those opportunities might look like in practice and how they might look commercially. I don't know if you have any insight into that aspect at the moment.
Yeah, so we have the Woodland Carbon Code, and it's still a little bit of an artificial carbon market at the moment. So I think what we'll see is a move to a proper trading platform, and that trading platform being extended to soil and also peatland sequestration. And I think what you'll see is that moving away from a public sector government led scheme to one which is operated much more by financial institutions and companies linked to obviously the requirement for larger companies to report annually on their carbon footprint. So they'll be looking to offset these, and you'll see a more mature and proper carbon market in the future. But we're a few years away from that at the moment.
Great, thank you. Scott, one has come in for you, asking about, obviously, just now with the concerns around COVID, there's a question about whether it's possible to deny access to a telecoms operator at the moment, just given concerns about risk of transmission.
Well, telecoms is recognised as being part of the critical national infrastructure, and obviously its importance has been even more apparent during the COVID outbreak. Even during full lockdown, telecoms operators were allowed to carry out essential works, and as restrictions have lifted, routine works are now being carried out with appropriate mitigations put in place. If an operator requests access, then you should continue to comply with your obligations under any agreement. You can certainly ask if access or works can be delayed due to concerns about COVID transmission. If that's not possible, you can ask for a copy of the operator's risk assessment and the steps that will be taken to minimise the risk of transmission. But ultimately, no, I think it's unlikely that you can or should attempt to deny access.
Okay, thank you. There's a couple of private residential tenancy questions, or sorry, housing sector questions for Claire and Fiona. So Claire, in your talk, you talked about the energy efficiency standards. And so it's a question about if works have already been carried out, can they count towards the cost cap? I don't know if it's you or Fiona to answer.
Fiona, are you going to answer that one?
Yeah, thanks. I will, but the answer, unfortunately, is that it's not quite clear at the moment. The cautious answer would probably be no, and we were certainly advising people last year that they should wait until the regulations came out because we didn't know exactly what they're going to say. We've seen them now, but we don't know what they'll update to. We do know there's lobbying going on in the background to include a longer time period for inclusion of works in the cost cap, and hopefully to retain that 1 April 2020 date, because we know that owners might already have had works planned to be included and hoping to allow them. We know that SLE and others wrote to the Minister in charge seeking commitments on timeframes for works to go towards the cost cap and on a longer lead-in time generally from the regulations being finalised and standards coming into force for a year up from the kind of previously planned 6 months. But right now we don't know what's happening, so we just need to wait and see what the government do with those requests.
Okay, thank you. And just another one on housing as well. So there's a question about whether it's possible to rent a property to someone and have them bring it up to the repairing standard as part of that rental arrangement.
Claire, shall I take that as well?
Yes,
so the answer is probably no, or at least not easily. If you're looking to do this now, you used to be able to enter into arrangements with the tenant if you were granting them a sufficiently long lease, and they could take on works to bring it up to the repairing standard, or they could take on some of those obligations. And obviously the landlord might have kind of safety considerations in mind, but in theory it was possible to do that. Since the advent of the PRT, that's open-ended now, so it's no longer possible to bring yourself into the exceptions, because those exceptions require a lease for a minimum of 3 years to allow works to be taken on by the tenant. So if you wanted to try and do something, you probably can, but you maybe have to structure it as kind of a license for works before the lease starts, and with a PRT to follow. Although, to be honest, a tenant, because a PRT can always be terminated to sell a property, then there's no security for the tenant. So even knowing that he's getting a PRT after he's done these works, he might not want to enter into such an arrangement unless he's got some kind of reimbursement costs in a contract covering that.
Thanks, Fiona. I feel a bit like a radio host looking at the clock and asking questions, but one question's just been received that I do want to try and fit in, is for Sarah-Jane and Kate. Just Sarah-Jane mentioned landowners and tenants working collaboratively. Do we think this is going to be via JV business, share farming, contract farming, or simply variable rents in tenancies? That's assuming that tax won't drive that decision. Do either of you have anything you can quickly say on that topic?
So Kate, I would say primarily through non-tenancy vehicles. So yeah, JVs, contract farming, share farming, that's definitely where we're seeing it go.
I think so. I would agree. I think that is in line as well with a lot of the publications and the general direction of travel towards kind of non-tenancy structures. And whilst the non-tenancy structures maybe aren't quite as kind of tried and tested, you also have a lot more flexibility, whereas sometimes the idea of trying to do something clever within agricultural holdings legislation is not always an attractive prospect. So there's a lot to be said for some of the alternative structures, as we like to refer to them as.
Thank you all. So thank you very much to all of our speakers today, especially Sarah-Jane, and thank you all for dialing in today, and we hope that you found the session useful. Just to mention that you will be receiving information about future events. So please do get in touch with any of today's speakers if you have any queries. Contact details are there. Thank you, speakers, audience, all once again, and that's the end of this session. Thank you. Bye-bye.